Good morning, Dan. No worries. I'm going to wait 1 or 2 minutes just to see if we get a few more attendees, and then I'll start presenting. Sounds good. Okay, well, I'm going to begin. Good morning. My name is Chad Fine, and I am the in-house counsel for the Minutemen companies. We operate human resources, consulting services, as well as third-party administrators necessary in the management of workers' compensation claims. For me, I've been practicing in the area of workers' compensation employer defense for over 10 years, and I've been in practice for nearly 15, representing initially the rights of injured workers, and for the last 12 years, I've been representing employers in the area of workers' compensation. Prior to that, I worked in human resources and operations and compliance with the Steel Transportation Company from 2000 to 2006, and managed many employees. So I'm familiar with the needs and the concerns of many smaller employers and mid-sized employers in the Cleveland area. Today, I'm going to be talking to you about what's necessary to properly adjudicate a workers' compensation claim, and especially from the employer's perspective, who the players are, who what steps need to be taken in order to properly defend and put you as the employer in the best possible position to defend a workers' compensation claim. So the Ohio Workers' Compensation System was created to provide medical coverage and benefits for all covered workers who were injured in the course of and arising out of employment. There are 2 state agencies, the Bureau of Workers' Compensation, which you are all familiar with, and also the Industrial Commission of Ohio, and that is the state agency responsible for adjudicating disputes between injured workers and employers. I attend approximately 1,800 of those hearings per year. prior to working for Minutemen, for about 10 years, I attended 1,000 hearings a year. So I've attended numerous hearings of this nature, and seen a lot. So these are the players, and these are the parties that work together in the adjudication of a workers' compensation claim. As we indicated, there's the Bureau of Workers' Compensation. That's the state agency which manages the workers' compensation claims. The Industrial Commission, the state agency that adjudicates disputes. The employer, the claimant, or the injured worker. Then there is the Managed Care Organization. They're a private company. They've been certified by the Bureau of Workers' Compensation to medically manage treatment issues. It's an outsourcing situation where the Bureau outsources the decision as to whether or not to approve certain services within a claim, treatment, or whatnot. And they make the decision. They employ nurses and doctors. Minutemen operates one of these managed care organizations. There's the employer representative, and then the claimant's representative usually were attorneys, although as in the case of a third-party administrator, many times the third-party administrator will not send an attorney. They're not allowed to practice law in front of the Industrial Commission, but they are allowed to relay the employer's position, and they are allowed to review the evidence on file from a non-legal perspective. So how is a claim adjudicated? First, of course, as many of you know, a first report of injury form is filed that gives rise to a workers' compensation claim. The Bureau of Workers' Compensation will either decide to allow the claim or deny the claim. If it's an additional allowance issue, the Bureau of Workers' Compensation will send the matter out to an independent physician who will decide whether or not the additional allowance should be accepted in the claim or whether or not it needs to be adjudicated in front of the Industrial Commission. Numerous services are provided at the Bureau level. If there is a dispute, then the matter is sent to the Industrial Commission for a hearing. But at the Bureau level, there is no hearing, and any party that disagrees with the determination of the Bureau of Workers' Compensation may appeal that determination, which will eventually result in a hearing before the Industrial Commission of Ohio. And there are two levels of hearings. First, there is a district hearing. This is the second level of adjudication, but it's the first level within the Industrial Commission. The hearing is presided over by a district hearing officer. That hearing officer is not a judge. He's or she is an attorney hired by the state. Many of them had been in practice for 20 or 30 years prior to being hired as hearing officers by the state. There are no formal rules of evidence in these hearings. There are no court reporters unless one is requested by a party in these hearings. You don't have the drama that normally you would see in a trial, but it is an informal conference to determine how a matter should be adjudicated. Both parties, the employer and the injured worker and their representatives, have an opportunity to present evidence for or against the issue being heard. And then the hearing officer, within 7 days after that hearing, will issue an order, or what's called a determination, noted on a record of proceedings, which either party may appeal within 14 days of receiving that order by mail. And an appeal of that order, which is always 99% of the time, always happens because one party is unhappy with the determination of the district hearing officer. That appeal will result in a staff hearing. This is the third time a determination is going to be made. Remember, first we had the Bureau issuing a determination. Then we had the district hearing officer issuing a determination, and now the matter is being heard by a staff hearing officer. Once again, same situation. A staff hearing officer is an attorney hired by the state of Ohio. It's not a judge. There are no formal rules of evidence. Both parties have an opportunity to present evidence for and against their position. And there are no court reporters unless one is requested by a party. And as an employer, if you've been successful then the losing party, the injured worker or the employer, may request a third hearing that's discretionary if there has been a mistake of law or mistake of fact in the staff hearing order. Then the Industrial Commission of Ohio may grant the right to have a third level hearing in front of either the 3 commissioners who preside over the Industrial Commission in Columbus, or many times it's the regional administrator for the office in which the hearing was heard. In Cleveland, it would be Debbie Pickens Lynch. And there are 12 offices around the state of Ohio. One of those regional administrators may decide to hear your third level hearing. You should know, even with all good appeals that are grounded, there's been a mistake of law, been a mistake of fact, only about 3% of those appeals ever are granted a third level hearing. So as I was about to say, as an employer, if you've been successful in defending this workers' compensation claim at every single level, your reward is usually to defend the matter in front of the Court of Common Pleas, a trial court. The injured worker will 99% of the time appeal the matter if it's a right to participate issue. In other words, whether a claim should be allowed or denied, to the Court of Common Pleas, and we will hold a trial on the issue. So what type of injury or disease is covered by a workers' compensation claim? As indicated, when I began the presentation, I noted that an injury must be in the course and scope of employment and arise out of employment. But what does that mean? An injury includes any injury received while the injured worker is performing their duties. It's not, a claim may not be allowed for a psychiatric condition unless that condition is related to a physical condition already allowed in a workers' compensation claim, or the other exception to that is if that psychiatric condition results from a sexual assault. The injury or disability caused by natural deterioration of a body part may not be allowed in a workers' compensation claim. It must arise out of the course and scope of employment. And an injury or disability that has occurred when an employee is participating voluntarily in an employer-sponsored recreational or fitness activity is usually allowable in a workers' compensation claim unless that employer has had the injured worker sign a waiver prior to participating in that event. And if you don't have such a waiver in place, I'll say it now during the presentation, it's a good idea to have one in place. You can always contact someone in my office, and we're happy to help you draft one and have one on hand, so that if one of your workers is involved in a voluntary activity, such as a company picnic or a softball game, or maybe you, once COVID-19 is over, you go to some other type of community function as a company, and someone sustains an injury, unless that waiver is in place, there may be a workers' compensation claim allowed for such an injury. So one question that I receive from many employers, are there cases where workers' compensation will not cover an employee's injury? And there are several of them. One is a purposely self-inflicted injury. Obviously, that does not arise out of the course and scope of employment. An injured worker who hurts themselves intentionally did not hurt themselves while conducting duties to the benefit of the employer. If an injury results from intoxication, in other words, the injured worker was drinking prior to coming to work, alcohol, or some other controlled substance was being used prior to coming to work, or maybe even on the job, and that intoxication causes an injury, that is not the result of the course and scope of employment. That type of injury will not be covered. And we'll talk about that if we have a little bit of time at the end of this presentation. We'll talk about drug testing and why that's important. And horseplay. 2 injured workers are fighting or involved in horseplay. One example I like to use is, for instance, a factory worker who is using a conveyor belt. In the normal course and scope of employment, while they're using that conveyor belt, their hand might get caught on a part of that conveyor belt and that could cause an injury. That would be in the course and scope of employment. However, if that same injured worker has decided it would be fun to skateboard on that conveyor belt while in the course and scope of employment, and they sustain an injury, they fall off that conveyor in some way and sustain an injury, that would not be covered in the course and scope of employment. That is horseplay. Similarly, fighting between two employees is normally will not give rise to a workers' compensation claim for the injured worker unless that fight has something to do with work. That's the one exception to that particular situation. In other words, same conveyor belt situation. One employee is unhappy with how another employee is moving boxes down that conveyor belt. It results in a fight, which causes an injury that may be covered by a workers' compensation claim. However, same two employees who are fighting over something outside of work, for instance, let's say one is a Cleveland Browns fan, another is a Pittsburgh Steelers fan. I'm a huge Cleveland Browns fan, so I understand how these things could happen. But it results in a fight at work. Those types of things will not be covered under a workers' compensation claim because the subject matter of that fight was not related to work. Some employers require their employees to travel. A travel-related injury may be covered under a workers' compensation claim. There is something called the going and coming rule. And that rule says where an employee has a fixed place of employment, in other words, they come to the same place every single day to begin their workday. They go to the same office environment every day. They travel from their house to an office. They work in that office till the end of the day. Then they get back in their car and they drive home. That employee's workday does not begin until they are on the property controlled by the employer. And any injury sustained while the worker or the employee is traveling from their home to the property controlled by the employer, when that employee is traveling to the same place of business every single day before they begin their workday, is not covered by a workers' compensation claim. Similarly, once they leave the premises and travel home, that would not be covered by a workers' compensation claim. But conversely, there are some employees that have a variable situs of employment. A computer repair person, or maybe an electrician who travels to a home every day or to a business, a different place every single day to begin their workday. They get an order tomorrow when you'll take the company van, which you have at your house, and you're going to drive it to this particular address to perform this particular job. And then the next day you'll do the same thing some other place. They go to a different place to begin their employment every single day. Their workday actually begins when they leave their home. And so any injury sustained while traveling to that place of business to perform their job would be covered under a workers' compensation claim. That's a difference between a fixed situs of employment and a variable situs of employment. It's important to understand the difference because many employers become frustrated, understandably so, when one of their employees are injured while traveling to one of the variable situses of employment that they work. One way to protect yourself is have your employees come to the same company headquarters or company offices at the beginning of each day to pick up any supplies they need, any work orders that they might be completing at the beginning of every single day. So they're always coming first to your place of employment and then are dispatched from that place. In such a situation, their injuries while traveling to work and at the end of the day home would not be covered by a workers' compensation claim because they would now become a fixed situs employee instead of a variable situs employee. Are stress-related conditions covered by a workers' compensation claim? Because remember, we talked a few minutes ago that purely psychological conditions are not covered unless they arise from a work-related injury. In other words, a psychological injury, I cannot file a workers' compensation claim because I feel depressed or because I feel some type of anxiety from coming to work. However, if I have a workers' compensation claim allowed for a physical condition, for instance, maybe a head injury, or maybe even another physical injury that is causing me anxiety and causing me to feel depressed because it's changed the way I live my life, then that might give rise to a psychological condition as an additional allowance in a workers' compensation claim. But a mental condition purely caused by work-related stress will not be a reason to give rise to a workers' compensation claim. Work-related stress is treated differently. An individual might suffer a stress-related heart attack. Such an injury will only be covered if that heart attack results directly from something that occurred at work. Now, claims might be additionally allowed for substantial aggravation of a pre-existing condition. For instance, an injured worker has pre-existing knee arthritis, kneecap, we call it the patellofemoral joint. They might have, there's 3 compartments in that knee. We might say that they have tri-compartmental arthritic changes that pre-existed the workers' compensation claim. And then while the injured worker is at work, they suffer a contusion or a bruise to that same knee. They fall down on that knee, direct impact, and now that pre-existing degenerative condition that affected the knee has become much worse. It's been accelerated beyond where it would have been had the work-related trauma not occurred. In that case, if the injured worker can prove by objective findings, maybe there was an MRI that was taken prior to, or an X-ray that was taken prior to the workers' compensation claim, the date of injury in the workers' compensation claim, and then there was an MRI or an X-ray or some other type of imaging, a CT scan taken after the date of injury, and we now show a significant change, a substantial change that would not have been there but for the trauma that gave rise to the claim. Now we can have a claim additionally allowed for substantial aggravation of a pre-existing condition. However, the claim may not be allowed for that pre-existing condition if it was not substantially aggravated. In other words, there are doctors' opinions on file that would indicate the condition has not been made worse by the trauma that gave rise to the claim. The injured worker must show by objective evidence, and they might support that objective evidence with subjective reasons. In other words, it hurts now and it did not hurt before. That would be a subjective reason. They must show with that type of evidence that the pre-existing condition has been made worse. Claims may also be allowed for occupational diseases, and this is particularly relevant today in an age where many people are filing workers' compensation claims for COVID-19. And COVID-19 is known as it would be handled in the under Ohio workers' compensation law is an occupational disease. And an occupational disease is contracted in the course of employment. The nature of employment puts the employee at risk of contracting the disease at a greater risk, to a greater degree, and in a different manner than what would be true of a member of the general public. So for instance, in the COVID-19 example, a first responder or a healthcare worker, or a doctor or a nurse would likely be at a greater risk of contracting COVID-19 than I would be, because the doctor or the nurse or the first responder are circulating with the general public and treating sick people on a daily basis, many of them with COVID-19. And I don't come into contact right now with many people because of isolation, and I'm working at home. And so that person is at a greater risk of sustaining COVID-19 than other people in the general public. If the person can show that they have the disease that's been diagnosed, that they are at, and that can be diagnosed either by a positive test, or sometimes doctors use other factors to diagnose the condition. You may not need an actual test to show that you have COVID-19 or any other type of occupational disease. It just might be has to be a diagnosis by a medical professional. And two, that they are at a risk of sustaining the disease that's greater than that of the general public. They might be able to sustain an occupational disease. So, as we indicated, occupational diseases are not easy to prove. The claimant has the burden of proof that it was that the COVID-19 was sustained in the course and scope of employment, arose out of employment, and they have to meet this 3-factor test, which I briefly referred to. The disease was contracted in the course and scope of employment, is peculiar to the claimant's employment by its causes and characteristics and manifestations. In other words, the employment puts the injured worker in a unique position to sustain the disease. And then, of course, the employment creates a risk of contracting that disease that's greater than the risk faced by the general public. As indicated, for the first element, the claimant has to prove they were exposed to the virus, they received a medical diagnosis for the disease, and the doctor or another medical professional causally relates the diagnosis to employment, and the employment itself has to have placed the injured worker at a risk that's greater than the risk faced by the general public. And we talked about a few minutes ago, healthcare workers and first responders might be able to establish these elements easier than people in other occupations. Remember, communicable diseases like COVID-19 are not typically workers' compensation claims. In other words, the flu, because it's very difficult to prove where an injured worker might have sustained other communicable diseases. And I will say over time, coronavirus will become more commonplace, I believe, or hopefully with the vaccine will become less commonplace. But either way, it'll be harder to prove over time where the disease was contracted. Quarantine itself will not give rise to a workers' compensation claim in Ohio. The Ohio Department of Jobs and Family Services does provide compensation for injured workers who are forced to quarantine, but not the Ohio Bureau of Workers' Compensation. A pre-existing disease that's been aggravated by a workers' compensation claim is not generally a reason, or is not generally a condition that can be allowed in a workers' compensation claim. One of the defenses we use with occupational diseases and any other type of injury is whether or not an injury is idiopathic in nature. In order for a workplace injury to be compensable, it must arise out of the course and scope of employment. However, an injury that arises out of employment where there is some causal connection between the conditions, where there is not some causal connection between the condition, and the injury, and work, is not a reason to give rise to a workers' compensation claim. For instance, an injured worker's knee that simply gives out for no other reason is not a mechanism of injury that would give rise to a workers' compensation claim, but an injured worker that trips over something at work and the injured worker falls, causes an injury, may give rise to a workers' compensation claim. An idiopathic injury is generally described as one that arises from the circumstances peculiar to the injured worker's employment. An idiopathic injury is an injury arising spontaneously. And I'm going to pause here because it looks like I've come to the end of my time. But if you have any questions concerning these concepts that we discussed today, defenses to workers' compensation claims, situations that may or may not give rise to workers' compensation claims, feel free to contact me. And I'm going to put my contact information up on the screen here so that if you have any questions, I'll be happy to answer them at any time. I thank you for your time, and I look forward to talking to you in the future. Thank you.